Contempt of court as a concept that seeks to protect judicial institutions from motivated attacks and unwarranted criticism, and as a legal mechanism to punish those who lower its authority. The concept of contempt of court is several centuries old. In England, it is a common law principle that seeks to protect the judicial power of the king, initially exercised by himself and later by a panel of judges who acted in his name. Violation of the judge's order was considered an affront to the king himself. Over the time, any kind of disobedience to judges or obstruction of the implementation of the directives or comments and actions that showed disrespect towards them came to be punishable. Well, coming to the definition of contempt. Contempt of court may be said to be constituted into disrespect or disregard, or to interfere with, or prejudice parties' litigation, or the witness during the litigation. Lord Hardwicke, in 1742, made a threefold classification of contempt. First, scandalizing the court. Second, abusing the parties who are concerned in the cases in the presence of the court. And third, prejudicing the public against persons before the case is heard. History of Contempt of Court, India. Contempt of Court of Record was introduced into India by the British following the establishment of the Courts of Record in the 19th century. This was put on the firm basis in India by the Contempt of Court Act 1926, which was left on the account of the differences of opinion between the Madras and the Bombay High Court on the one hand, and Calcutta High Court on the other hand, regarding the protection of the subordinate courts. The Act did not contain any provision with regard to the contempt of court subordinate to courts, other than high courts, that is, the courts subordinate to chief courts and judicial commissioners. The Act also did not deal with the extraterritorial jurisdiction of high courts in the matters of contempt. The Contempt of Court Act 1926 was found adequate, and as such the Contempt of Court Act 1950 was enacted. From the statement of objects and reasons which led to the enchantments of the Contempt of Court Act 1952, it is obvious that this law was made as there was no specific provision of law which enabled a high court to exercise his power in respect of contempt committed beyond its territorial jurisdiction. Well, coming to the types of contempt. Contempt can be criminal or civil. Criminal contempt involves an intentional interference with the administration of justice, while civil contempt is disobedience to orders or judgments of the court, with only knowledge of the order or judgment, not intent to interfere, being needed. Civil contempt requires only preponderance of the evidence, while criminal contempt requires proof beyond reasonable doubt. Another significant distinction arises from whether the contempt occurs in the face of the court or outside it. Contempt beyond the courtroom is much harder to prove. Civil contempt in detail. Section 2B of the Contempt of Court Act 1971. The essential ingredient is willful disobedience, and not any and every disobedience, due to various reasons such as delay due to unavoidable circumstances. It has to be proved that the disobedience was willful. A civil contempt involves disobedience to a court's order affecting the rights of other parties to that order, basically denying the rightful fruits of the suit to the other party. Criminal contempt in detail. Section 2C of the Contempt of Court Act 1971. It is seen that scandalizing or prejudicing a judge or interfering with the administration of justice is contempt. Even tending to scandalize or tending to prejudice or tending to interfere or obstruct is enough to invoke action in criminal contempt. My first case study is Val Thackeray versus the Bombay High Court. In a relief to Shiv Sena Supremo Bal Thackeray, the Supreme Court on November 29 set aside a Bombay High Court order of 1997 convicting him for contempt of court for levelling private charges against a judge in his Dasara public speech at Shivaji Park in Mumbai in 1996. A bench comprising Justice Y.K. Sabharwal, Justice D.M. Dharmadhikari, and Justice Tarun Chatterjee, in an unanimous decision, said as the contempt proceedings were initiated at the behest of the private party. The latter should first have obtained the consent Octate General of Maharashtra. So, what happened in this case? Let's talk in detail. As no consent was obtained before filing of the petition by the Congress leader Harish Pimpal Khote, the High Court committed an error by going ahead with the contempt proceedings. Sena Supremo was sentenced to imprisonment for 1 week and asked to pay a fine of Rs 2000 by the High Court, which held him guilty of making a contemptuous remark, which were published in the party mouthpiece Samna. The apex court also squashed the High Court order against Samna editor Sanjay Raut and printer publisher Subhash Desai. The court also directed that the amount of fine deposited by the appellants be refunded. The bench accepted the contention of the appellant's counsel, P.H. Parekh, that the apex court had laid down a law in P.N. Duda case that if a private person requests a high court for initiation of criminal contempt against another, then the petitioner must seek the consent of the concerned advocate general. With this, the case study ends. So, the second case study is Vijay Mallya versus the Supreme Court. The apex court in May 2017 had found Vijay Mallya guilty of contempt of court in a plea filed by a consortium of creditors led by State Bank of India. The plea alleged that Mallya had disobeyed the court's order by making vague and unclear disclosure of his assets by transferring $40 million from Diageo PLC to his son Siddharth and daughter Liana and Tanya, and violated the orders passed by the Karnataka High Court. The High Court had specifically ordered Mallya not to transfer or alienate any movable and immovable assets to any person. So, what happened in the case? Let's talk in detail. A bench comprising Justice U.U. Lalit and Ashok Bhushan said, "We do not find any merits. Review petition dismissed." The apex court had reserved its verdict on the review plea on August 27, 2020, after hearing arguments from both the sides. Mallya had filed the petition seeking a review of the apex court's May 9, 2017 order by which he was held guilty of contempt of court, transferring $40 million to his children in violation of the order. The fugitive businessman, who is an accused in a bank loan default case of rupees 9,000 crores involving his defunct Kingfisher Airlines, is presently in UK. So that's all to the case. Eventually, we can say that contempt of court cases never come to an end. It's an ongoing process. The discussion in the Supreme Courts and the High Courts are never ending. Hence, we don't have any conclusion to all those cases. With this, PRACHEE PREKSHA is signing off. Thank you.